Did you know that even if an accident is not your fault, you could end up losing your entire personal injury claim? Or you could do something that drastically reduces the value of your claim. There's a few common mistakes that I see all the time that either eliminate people's claims or significantly reduce the compensation that they receive. So let me go over these things. And again, these are for informational purposes only. Every case is different. But as a California personal injury attorney that's been practicing for over 25 years, these are things that I commonly see that either eliminate your case or reduce the value by significant margins. First of all is admitting fault too early. When you're at an accident scene, you're emotional. It's not something that anybody wants to go through. It's understandable that you would make statements potentially at the accident scene or shortly thereafter to insurance adjusters that you were at fault or partially at fault or you're sorry. Don't say any of those types of things. Wait and consult with an attorney who's familiar with liability laws in California. Wait for the police report. Wait for other information, witness statements, etc. These things will provide the information you need to really determine liability. And if you admit fault too early, that statement can and will be used against you later in the case. The second thing I see is delaying medical treatment. You don't want to delay medical treatment, first of all, because the later you treat, the more complications you could have from a medical standpoint. But also, there's always an argument from the insurance adjuster that if you were really hurt, you would have gone to the doctor sooner. And that's something that they throw up in your face pretty much every time. So you never want to do that. I can think of countless examples where clients have felt like they were okay and had some aches and pains, weren't sure whether they wanted to go to a doctor or not, waited weeks or sometimes even months to go get checked out. And it turns out they get MRIs or other radiographic studies that show there's a serious problem. But the insurance company says, well, something could have happened between the time you initially had the accident and when you actually went to see a doctor. And so we're going to make sure that you're not going to get compensated based upon that argument. So don't ever do that. Don't talk with adjusters without the help of an attorney, especially the other party's adjuster. They're not your friend. They're not there to help you. No matter what they tell you, we're just trying to get to the bottom of things. Just needed to get a recorded statement from you. They're going to ask questions that help them, not you. They're also going to ask very vague questions like, was the impact light, moderate, or heavy? Was traffic? Those types of interviews are not there to help you, and they can end up actually hurting you if you make the wrong statements to the insurance adjuster. Not documenting the accident properly is another mistake you can make. At the scene of the accident, if at all possible, pull out that cell phone you've got in your pocket. It's a very helpful tool. You can take photographs or video of the positioning of the vehicles, the damage to both cars. You can get a recorded statement from witnesses at the scene, or at least get their information. You should definitely take a picture of the other party's driver's license and insurance information so you don't lose track of that later and not have the ability to open a claim with their insurance. So that's one mistake. Posting on social media is another biggie. Everybody likes to be on Facebook, Instagram, and show, how much fun they're having at their ski vacation or at the beach or anywhere else. But all those posts can later be discovered by an insurance adjuster who says, hey, listen, you claim to be hurt, but yet you were out skiing on such and such a date. And that's just not something you want to do. You basically want to, not talk about anything related to the accident on social media, but also not be posting videos of you doing very active things when you're claiming that you're hurt. The next mistake I see is signing papers without legal advice. In California, once you sign a release of claims, that's the end of your case. There's something called a 1542 waiver in there that basically says you're waiving not only all claims that you know about and injuries you know about, but anything that you don't know about and may find out later. So you're waiving all present and future claims once you sign a release in California, and you should never do that. You should also never sign a blanket authorization for the insurance company to obtain all of your medical records. They're going to go back years, try to find any prior condition you had, any prior treatment, and use that as an excuse to say, hey, it's a pre-existing injury. It's not something that was caused by the accident. And I can think of numerous times where clients have signed those types of authorizations and it later comes back to haunt them. Waiting too long to talk to a lawyer is another big mistake. You should absolutely speak with an attorney if you have any injury at all and you intend to file a personal injury claim. You should get an attorney retained, in my opinion, if it's any type of significant injury, because the statistics show that you're going to end up getting a lot more for your claim, even accounting for attorney's fees and costs than you would have it without representation. And the quicker you talk to the lawyer, the more you're going to know what your case is about, how to determine liability. The attorney can help you obtain medical treatment beneficial both for your health and for the case later on. Not following medical advice. If a doctor tells you to stay home from work and you don't do that, or if the doctor tells you they want you to do 3 sessions of physical therapy a week every week and you only do 1 or 2, those types of things are going to come back and be thrown back in your face and be used as an excuse by the insurance company to not pay you. So you definitely want to follow medical advice always. Giving in to the first settlement offer. That's another big one. A lot of times people come to me and they say, hey, listen, I didn't think the accident was that big of a deal. I thought I could represent myself. They sent me an offer that basically said that they would pay my medical bills and give me $500 to boot. It seemed like a good deal at the time, but now I'm finding out that I have herniated disc based upon the MRI, and I've already signed a release. Again, once you've signed that release, the case is over, and accepting that early settlement offer is now something that you're stuck with, and you can't receive fair compensation or even get the proper treatment that you need. These are big mistakes I see all the time. These are things that can eliminate your case or reduce the value drastically. So if anybody has a personal injury claim, whether it be a car accident, slip and fall, any type of injury claim, and they're confused about what their legal rights are and who's liable and what type of damages you may be entitled to, give us a call at 866-966-5240 or visit us on the web at victimslawyer.com.